Is wholesaling illegal in Oregon? No. As of today, Wednesday, March 13th, 2024, House Bill 4058 has been passed. And you need to figure out exactly where you're at if you're a wholesaler, a buyer agent, a listing agent, or anybody out there doing professional real estate activity. My name is Dan Gandee from the Operative Group, and I have a highly specialized real estate team that operates everywhere from Portland to Roseburg out to the Pacific Ocean. And we specialize in investment properties and working with house flippers, investors, rental property owners, and wholesalers. And this is a huge development, what is going to happen moving forward. So let me go through the summary of House Bill 4058 and explain why wholesaling is not illegal, but you must do it legally or it will be illegal. The Act adds a law about residential property wholesalers. The Act changes the laws about real estate licenses. The Act adds a new defined terms. The Act defines the future right to list contract and states that a real estate license may not take certain actions if the contract lasts more than 24 months. It creates a residential property wholesaler registration, which we're going to talk about here in a second. It prohibits residential property wholesalers without registration, so it can be illegal. It provides exceptions, but also punishes with a violation of a maximum of 364 days of imprisonment or a fine of $6,250 or both. It also creates civil penalties. It also creates that real estate license acting as buyer agents must use written buyer representation agreements. I can just unpack that to the finish line, but we're going to cover wholesaling first. It also has or requires acting as seller agents to use written listing agreements. That's been in place forever. But it also requires real estate license to disclose shared compensation, which our brokerage has been doing since all of the NAR lawsuits. And it prohibits the real estate license from entering into a long-term agreement that requires buyers or sellers to use their services in the future, which I would call a listing option agreement or a future right to list, okay? Which we actually had somebody we know that worked for a company that was doing that with lots of lawsuits. So let me break this down really quickly. And there's a lot of information in here, and I'm going to summarize it as quick as possible so that you can get the brass tacks of it. Full disclosure, I am not a real estate attorney or an attorney or a legislator, but I have taken my own time to break down what really happens in Oregon if you're a wholesaler moving forward. All right, let's break it down. Market means to advertise or contract with another person, entity to advertise or solicit purchasers for the purchase of a property, either publicly or privately. Guys, let's break this down. There was two parties for wholesalers, bad wholesalers and good wholesalers. Good wholesalers were disclosing their and or assigns contract and their assignment fee. Bad wholesalers were misleading people and thinking that they were the actual end buyer of that property, showing fraudulent proof of funds, showing that they had a list of partners that weren't actually in an entity with them, and they were selling that contract privately after the close using a double close action typically. Now, in the good and bad wholesaler camp, I'm an active investor. I've bought deals from wholesalers, good and bad, but I know at the end of the day that full disclosure is not being done. But also as a real estate broker, I noticed that wholesalers were really walking the line of professional real estate activity. They were marketing it publicly on Facebook groups. They were marketing it publicly on classifieds and Craigslist. They were sending it out to email lists. That is actively doing professional real estate activity. And now Oregon is requiring these wholesalers to be registered. And when they're registering, they have to be background checked, fingerprinted, and go through the same process as real estate agents. They must have a GED or a high school diploma. They must have a criminal or non-criminal record that suffices the real estate board. Okay? And what I want to really talk about is that this means there's higher standards for wholesaling moving forward. There is a tracking system, there's transparency, and there is fines, which is going to create roadblocks at title and escrows. Every wholesaler out there that thinks they're going to still be able to get away with it because they're going to be able to get the and or assigns contract out there, guys, I got news for you. The title company is going to be your roadblock because you can't transfer the deed or transfer property without the title and escrow license signing off. this is going to be their roadblock, just like FERPA, just like IRS rules, just like anything else that lenders also require in making sure everything is fully compliant with title and escrow process and recording with the county. Guys, this is going to create a process in which legitimizes wholesalers, but they must follow the steps. All right. Registration requirement is, like I said, goes through a pretty standard process, just like a real estate agent. And this section applies to every person who conducts residential property wholesaling related to property located in the state. Doesn't mean you can't wholesale outside of the state, right? All of that being said, there are fines. You can be sued. It allows a buyer who is not given proper disclosure throughout the process that you are a registered and licensed wholesaler the ability to cancel the contract at any time and also have all of their attorney fees and anything related to a lawsuit paid for by the wholesaler. So you have to be very careful here if you're reading through this, okay? I just wanted to say that the only people exempt from this law are conservators, power of attorney, sorry, not power of attorneys because those are not court appointed, conservators, personal representatives, trustees of bankruptcy cases, and anyone that's elected on behalf of a court appointment in order to be able to facilitate the transaction, meaning the same reason for seller property disclosure, why they're exempt, okay? Now, I just want to let you know that there is a lot of information to unpack here, but the biggest part about this Wholesaling Registration Act is the disclosure portion. The disclosure is disclosing that they are a wholesaler, they are licensed, and they are going to have interest in selling the contract to another party. All right. Just like a real estate agent signs a listing agreement and discloses how the compensation is going to be paid to the buyer agent and the seller agent, it's going to disclose that they are and or assigning and selling that contract to a third party for an interest or payment. All right. And I want to make sure that everybody kind of understands that was one of the biggest problems that we were seeing. Sellers are being misled. There was people showing the property to other parties that were not actual partners or a part of their entity or any way involved. They were marketing those properties. That's professional real estate activity, regardless of what you say. Now, I've and or assigns contracts to my own entities, which this law talks about. That's okay. If I go to John Doe and say, I want to buy your house for $250,000, but I put and or assigns to a partnership or LLC owned by the buyer, that's and or assigning to another LLC that I own. That is okay. I am a principal in the transaction. I am not removing myself from the transaction by getting paid. All right. Want to go through this in a couple more aspects, but the biggest thing to understand is that there are going to be fines, misdemeanors. There's going to be a governing body looking at the penalties and at the violations, just like a real estate agent has to deal with the real estate board if they get a complaint. Now, I want to make sure that everybody understands that this is a serious business because now the title company is going to be the roadblock. The state is going to be the monitor. Everybody who thinks they can get around this, I got news for you. It's not going to be good. Now, let's unpack the second part of HB 4058, which was listing agreements, buyer representation agreements, and the 24-month rule in terms of the listing contracts for future sales. All right. First thing I want to talk about is listing agreements. Any seller that engages in selling a property must have a listing agreement in place. I want to keep this in mind. To anybody out there who thinks they're going to for sale by owner it and tell an agent to bring them a buyer, but market the property to their database, that is selling the property for the for sale by owner. Any activity of marketing that property could be, in my opinion, treated as a seller engaging with a selling agent to market the property in order to gather buyers to bring them. So self-representation arguments, selling agent arguments are going to come up with this. But this is for certain. If you're going to sell a property and you're going to hire a real estate broker to do it or a wholesaler, you must disclose what that payment is going to be and have a listing contract in place as a licensee. All right. Sellers need to understand that. Second thing, buyer representation agreements. This is huge. There's a lot of tire kickers out there who want to go see a property, open doors. They'll hit you up on Zillow, Realtor, and all these different websites. And all they want to do is look at the property. They haven't talked to a pre-approval. They're basically just calling numbers all the time and having a million different real estate agents think they're going to work with them. Well, as buyer agents now, we're required by law to have a buyer representation agreement in place. And I want to really touch on this specific fact, is that the buyer representation agreement is going to help with understanding that who is representing the buyer in the transaction. All right. A real estate license representing a buyer is required to act under a written representation agreement with the buyer. The representation agreement must be entered into before or as soon as reasonable practicable after the licensee has commenced effort to assist the buyer in purchasing a real property or identifying real properties for purchase. Boom, setting up property searches. Next, state whether the agreement is exclusive or non-exclusive. Describe the legal obligations of a buyer agent described in the section either directly or referenced by the initial agency disclosure pamphlet under ORS 696.820. And if such plan has been provided to the buyer and contain any other additional requirements prescribed by the rule of the real estate commissioner. A real estate license may not enter in a representation agreement or contract that would require the buyer to enter into a representation agreement in the future if the duration of the representation agreement or contract, including any automatic renewals, the representation agreement exceeds 24 months. So these are 2 years or less representation agreements. The requirements of subsections 1 and 2, the section does not apply to real estate license when engaged in transaction for a property that is improved or available for improvement by commercial structures or 5 or more residential dwellings. So commercial brokers do not have to follow this rule. A real estate license who acts under a representation agreement with a buyer acts only as the buyer agent in a real estate transaction unless the buyer has agreed in writing that the buyer agent to be disclosed limited agent against pursuant ORS 696.815. Now I want to talk about this, guys. That means that when you call a number on a sign and I'm the listing agent and you don't have a buyer agent and my disclosed limited agency for seller says I cannot represent buyers, they can't refer you to an agent in their brokerage because the principal broker is going to be in a dual agency situation unless the buyer agrees to it. So this is going to lead to more intro or out of broker communication between different brokerages. This is super important and I think is super valuable. All right. Next, in all of this, before entering in an agreement to share compensation between a listing agent and a buyer agent, the listing agent and the buyer agent must disclose to their respective clients the amount in terms of the shared compensation. Now, our brokerage has this. The RMLS listing agreement has this. It says, what is the seller paying the buyer agent and the selling agent? And now we need to disclose this to the buyer when we go into contract, and all parties are aware of how compensation is getting paid. We have this documentation already. It probably is going to be revised by attorneys, but I just want to let everybody know that you have a listing agreement in place or a buyer representation agreement in place, and then all parties are aware of how compensation is going to be handled. This is clear. Last thing, a part of this law, part of HB 4058 is the future right to list contract. I always thought these were bogus. This is like a real estate option agreement for listing agents. They were paying a consideration to a seller to force their hand in getting a potential listing in the future. Really what that is that they were going around writing checks to people and saying, hey, when you sell your property in 2 years or 5 years, you have to list with me. People were taking that money and then they were breaching the contract. There was a bunch of civil lawsuits about it, and that is going to stop. They may not solicit, enter, or give, receive compensation arising from future right to list contract if the duration of the contract, including any renewals, or they exceeds 24 months. The section does not apply if the future right to list contract is entered in between a real estate license and a corporation, an LLC, or a partnership, and is for the right to list the real property of the corporation, limited liability company, or partnership. So you still can do this with investors or partnerships or corporations. Just wanted to share that. A lot of these laws that are in SB 4058 are based upon non-commercial real estate. But what it does do is it creates transparency. It creates the buyer and selling understanding how compensation is made. It creates a system of tracking and oversight. And it also creates a clear and concise MLS compliance between all the different MLSs in Oregon. That should be one. That's my opinion. on how listing agreements, buyer agent agreements, and future listed contracts are treated in Oregon. If you guys have any questions, or you're an investor and you refuse to sign a buyer agent compensation agreement, that's okay. We get it. You want to shop around, but to show you a property, we got to have one signed. That's as simple as it is. Thanks for watching.